Hi, I'm Anna Denton Jones of Refreshing Law and welcome to my first video of 2020. Happy New Year to everybody. I apologise for the gloominess of the recording. It's the middle of the day, I've got all the lights on and it's still a very grey day out there. Today I want to focus on investigation meetings and the extent to which an investigation meeting, sometimes called a statement meeting, or a fact-finding meeting, the extent to which it is required that you have a separate meeting of that nature to a disciplinary hearing in any disciplinary process. Now, the starting point is going to be your procedure. If you have set out in your staff handbook or in your disciplinary procedure to staff that there will be a separate meeting, then it may well be unfair if you don't follow what you have promised people you're going to do. But aside from that kind of promise made in a document, if you look at the ACAS Code of Practice and what it advises employers, it actually says that it's important to carry out investigations without any unreasonable delay to establish the facts of the case. So far, so good. We know we need to find out what's happened. But it then goes on to say, in some cases, this will require the holding of an investigatory meeting with the employee before proceeding to a disciplinary hearing. But it then also goes on to say, in others, the investigation stage is just going to be the collation of evidence by the employer for use at that disciplinary hearing. So it's going to depend on the particular situation in front of you. Often it will make sense to have a meeting with the person who is accused of misconduct to find out what has gone on and take a statement from them as part of your investigation. There may well be other witnesses that you need to interview as well. And quite often you will need to put together everything that's been learned as part of the investigation process into some kind of a report, separate document that can then be given as a pack to the person who is accused of misconduct with an invitation to a disciplinary hearing. But it's not the case that you've always got to have that separate stage, unless, of course, you've spelt out that that's what you're going to do in your policy or your disciplinary procedure. This was discussed in a recent case called Sunshine Hotel and Goddard. The judge there was pointing out that it's not a legal requirement of Section 98(4) of the Employment Rights Act, which is the test for unfair dismissal, that you hold an investigation meeting in order for it to be fair. It simply requires an employer to have acted reasonably, and quite often acting reasonably is going to include the investigation meeting and having that investigation stage, but it's not an absolute requisite. So there will be cases where you've already got perhaps an admission from the employee that they've done something wrong. You've suspended them and at that point they've told you, yes, I did it. You might not need to go much further than that. Or you might have all the documentary evidence of, I don't know, somebody fiddling their expenses. The paperwork might tell you everything you need to know without really having to do much more. So it's very much horses for courses. What I would say is, in terms of investigation stages, I'm concerned often that employers are asking people to do investigations who have not had any training in how to do that investigation stage. And that seems a little bit unfair to be expecting somebody to look into what has gone on without perhaps having the skills to do that. If we are concerned that people haven't got the right skills, there are an awful lot of HR professionals out there who can come and help support the investigation stage, help you put together findings and actually be that independence, bring that to bear on the situation as well. So if that is something that's of interest to you, do let me know. My email is adenton@refreshinglawltd.co.uk. I look forward to hearing from you, and Happy New Year again.